Hello, this is Professor Najri Mathis Rutledge. We're here today at the Fred Parks Library to kick off our segment on legal research. Legal research can be both fun and frustrating for most first-year law students. I hope to provide a few tips today to make it go more smoothly. Let's delve into legal research today. Before we can really talk about legal research, we need to do a little bit of review regarding the court system, basically things that we talked about during orientation. Remember, we have a hierarchy of courts in the United States of America. We have two independent systems, the federal system and the state system. The federal system essentially consists of three different levels. The lower court level is the U.S. District Court. That's the entry point for most lawsuits, followed by the Circuit Court of Appeals, followed by the Court of Last Resort, which is the United States Supreme Court. There are 13 federal circuit courts, and there are any number of federal trial level courts depending on the jurisdiction. Recall that federal district courts are known as the trial courts, and federal circuit courts are known as appellate courts. In Texas, we are in the Southern District of Texas if we were going to a trial level court, or we'd be in the Fifth Circuit Court of Appeals if we were going to file an appeal. One important concept that I'll probably be repeating throughout our time together is that there are two main goals in legal research: to find primary authority and binding precedent. Now, even though that seems simple enough, it's very easy to get excited about a secondary source or something that's a great case with a great fact pattern, but it's not binding. Now, although you can cite to these type of materials in your memo or brief, you really want to have the primary goal of finding the primary authority and binding precedent. Examples of primary authority would include cases, statutes, constitutions, and regulations. Now, many students get frustrated because they really want to start off with a computer and electronic searching. Electronic searching is based on hitting certain search terms, right? There are algorithms in the background, and if you get the right search terms, hopefully you'll get a hit. Print topics and search materials are organized a bit differently. They're organized by subjects and legal theories. So, for example, if you took an electronic source and looked up the word contract and breach, you would find thousands and thousands of documents that had those two words, not necessarily in any kind of relationship to one another. In a print source, you could actually look up the term or subject contract, and they would have all these subcategories, including breach of contract. Because of the way that print sources are organized, sometimes they end up being a much easier starting point for beginning researchers. Keep in mind, anytime we're looking at print sources, we have to consider currency. Is the print source up to date? To update print sources, they use something called pocket parts, or sometimes softcover supplements. You also want to know about the scope of coverage. Some electronic databases only go back to a certain point in time. For example, FindLaw at one point only looked at federal district court cases back to 1996. And if the best case that you can find is older than that, you may not find it on that database. So always know the scope of the coverage. This goes for your electronic sources and your print sources. Finally, you really need to think about cost effectiveness. Time is money. And as attorneys, your time is going to be very valuable. So how do we find case law? Well, you find primary law by using secondary sources. That's actually my favorite way of finding primary law. So that will be the first module that we'll discuss. You can also use case digests. You can use statute annotations, Shepard citations, electronic commercial services like Westlaw, like Lexis, like Case Manager. There's several new ones, Lois Law, FindLaw, and you can go on the internet. In order to research effectively, you need to have a plan. So let's talk about strategy. Research is both an art and a skill. Sometimes you think you're doing well and then you have a false start, find some dead ends, and you just have to be patient and be willing to start over again. Keep in mind, students often ask me, where should I start my research? Where's the best place to start? The truth is, it depends. There is no one right path to research. Each problem is going to be different. One important thing that you need to consider is, where do you like to start doing research? Some students have a very strong preference for starting maybe in a secondary source or on Google Scholar. So make sure you know your preferences, and it also depends on the information you already know. Money is going to be an important factor in the equation in terms of how you begin your research. Although students tend to gravitate towards electronic sources because they seem easier, they're not necessarily simpler. Electronic sources can be very expensive. Even though you have free access to sources like Westlaw and Lexis, keep in mind someone, namely the school, is paying for your free access, so it's not necessarily completely free. And when you graduate, it's definitely not going to be free. And oftentimes those expenses are passed on to the client. Some clients won't pay for those expensive search tools. There are free internet sources out there, and we'll talk about them, but keep in mind they're not always trustworthy. They may have very primitive search functions, and if it takes more time to find what you need, you're wasting money. When you begin with researching, first thing you want to do is brainstorm. This is very important, so I'm actually going to circle it for you. Why? This is actually going to be on your final exam. Where do you begin legal research? Brainstorm for search terms first. Professor Sparling says that thought before action saves time and money, and I think that's a quote worth remembering. In order to be effective with your research, you need to have a plan. Someone once told me not having a plan is a plan to fail. You need to figure out how to be cost effective. Know the importance of finding the right words. The words or your search terms are the key to finding exactly what you need. And while you have all this quote-unquote free access, this is the time to practice and make your mistakes and really sharpen your research skills. The best kind of research tools would be those exploding resources, because an exploding resource can lead to another big important source and another or another. So what do I mean when I say you've got to find the right words? Effective research is about finding those important keywords or key terms. There are basically two types. There are some keywords that are just going to describe the very aspects of your case. Maybe it's a torts case, maybe it's a criminal law matter. It may also describe the cause of action and the type of relief sought. So if you're doing a brainstorming activity trying to figure out different keywords based on the problem, think about the facts that you have and make a list. What thing or subject matter does the issue involve? What kind of law or actions are involved? Is there a cause of action that you already know of, or a defense? What relief is your client seeking? Are there specific person or places involved? Is this a landlord and tenant dispute? Is it an employee and employer dispute? What potential defenses can be used? Keep in mind that terms of art are going to be very important. That's the second type of keywords that you need. Terms of art essentially refers to words that tend to repeat when you're dealing with a particular legal issue. For example, if you were looking at intentional infliction of emotional distress, a tort, one key term of art that you would see repeated in almost every case is the phrase extreme and outrageous conduct. That's a legal term of art that's so important that if you typed it into Westlaw or Lexis, or if you looked in the books for it, you would find hundreds of cases that have discussed or further defined or developed that term. A great way to figure out what those important key terms of art are for a particular cause of action would be to go to secondary sources. Another important thing you need to think about before researching is figuring out your jurisdiction. You need to figure this out first. So frequently we have students looking for cases in the wrong jurisdiction. And remember, if you're in the wrong jurisdiction, you're forgetting one of the primary goals of legal research, to find binding precedent. Don't just search across jurisdictions if those jurisdictions aren't going to be relevant. Here are a few key questions you should ask. Is this a statutory issue? Does it involve the common law, a constitution, administrative law? Is it a state or federal law question? This should all help guide you in terms of where you should begin your research. Think about drafting a question presented. You can say something like this, under, and then just list or brainstorm all the possible governing areas of law. Does, think of all your potential questions, and then when, list all of your legally significant facts. Using this formula of under, does, when should help you in being focused on the precise issue that you're trying to research. When you get started, keep in mind whether this is a problem that a bar examiner is giving you, or your law professor, or even a client coming into your office. A fact pattern or a client narrative is not the same as a legal theory. Your job is to take the client facts and translate them into a legal issue. You've got to, while your client is talking about what a hard time they're having and all the difficulties, some things that they're going to say are going to be really relevant to the issue at hand and some's not. You've got to sort through all of that and figure out what the terms of art are going to be and the black letter law. You then have to figure out what the legal issues will be. Keep in mind, most legal resources are not organized by particular fact patterns, but by legal theories. Too often, students will get this great fact pattern from me and they'll try to match the fact pattern to case law. That's not going to work. You need to think more broadly. Think about the legal theories involved as opposed to a specific fact pattern. You need to identify terms of art that may apply to this situation. Keep in mind, a good place to start, once again, would be a secondary source. You also need to identify the black letter law. So we're going to close now, but keep in mind the goal of legal research: finding primary law and finding binding precedent. Primary law, again, consists of statements of law by the courts or legislatures. That could include case law, statutes, constitutions, administrative decisions, rules of court, and regulations. It may be binding, which is mandatory, or persuasive authority. I look forward to doing some actual exercises with you in class.